Okay, good afternoon, everybody. Welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thank you for joining us today. The Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. Additionally, we do help the Commissioner of Administration with issuing advisory opinions, and we also provide legislative assistance and a variety of training opportunities. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the page where you registered. We also record our webinars, so if you missed part of today's webinar or want to go back and watch it again or find one of our prior series, those are posted on the Data Practices Office YouTube page, which you can also find a link to on our website. You can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing those resources after the webinar. If you'd like to also download a copy of the PowerPoint right now, I'm going to take a minute to just share the file with you to download and save to your computer. So just give me one moment, please. Okay, so you should see a pop-up window on your screen, and you can select the file and download it to your device. I'll give you a moment to do that here. Okay, as I mentioned, if you didn't get it now, you can also find it on our website, which we'll share the link to that a little bit later in the webinar here today. So today's webinar is another installment of Data Practices Potpourri, where we will highlight some of the questions data requesters and government entities raised in March. We will leave some time for a Q&A session at the end of the webinar, so please feel free to send in your questions as you think of them using the Q&A panel on your screen. Make sure you choose all panelists when you send in your questions so we can be sure to see them. You can start sending them now, or you can wait until the end of the presentation. Okay, let's hop right into our questions. The first question we have this month is whether the Data Practices Act establishes specific procedures that government entities must follow to verify a data subject's identity when responding to a request for private data. This question is pretty important because government entities certainly want to make sure they don't violate the law by inadvertently disclosing private data to someone who is not authorized to access it. So, having identity verification procedures in place is an important way to ensure compliance with the Data Practices Act's data protection requirements. Okay, the Data Practices Act doesn't dictate specific procedures or protocols that government entities need to have in place to verify a data subject's identity before providing access to private data. Rather, the Data Practices Act generally requires entities to establish appropriate security safeguards for all records containing data on individuals. Ultimately, this means that each government entity has discretion to determine processes for how to confirm a data subject's identity before disclosing private data, and each entity should document those procedures in its data access policy for data subjects. The Data Practices Office website does have a model access policy for data subjects, which also has some examples of how a government entity can verify an individual's identity. These examples include requiring data subjects to provide a valid photo ID when inspecting data or obtaining copies in person, producing documentation establishing a relationship with a minor data subject when a parent or guardian makes a request, or requiring the submission of notarized copies of identifying documents if the subject requests copies of private data to be mailed. Again, these are examples, and each entity can determine its own procedures to verify data subjects' identities to ensure private data is not improperly disclosed. The next question we have today is whether a government entity can charge another government entity copy cost fees when sharing not public data as authorized by law. So the quick answer here is yes. Section 13.05, subdivision 9, permits a government entity to charge the requesting entity actual costs related to providing not public data. As a reminder, actual costs can include the cost of media, mailing costs, employee time to prepare copies, costs related to reproduction of data that an entity cannot do itself, as well as the costs related to employee time to search for and retrieve data. Additionally, the language of subdivision 9 is permissive, so an entity that maintains data is not obligated to charge the requesting entity copy costs, but it is an option that's available if needed. Next up, we have a question about photographs of employees. Specifically, can a government entity share a photograph of an employee when it announces that the person is the recipient of an award or honor? So, photographs of individual employees, such as a headshot or badge photo, would be classified as private personnel data under Section 13.43, Subdivision 4. Remember, Section 13.43, Subdivision 4 reverses the public presumption contained in the Data Practices Act, which means data about government employees are private unless the data are specifically designated as public under Section 13.43, Subdivision 2. Here, images of employees are not one of the categories of data that are designated as public in Subdivision 2, which means that photos of individuals are going to be private data about the employees. All that said, a government entity could disclose the photograph of the employee in this situation if it was able to obtain written informed consent from the data subject. Minnesota Rules Part 1205.1400, subparts 3 and 4, lay out the requirements for obtaining informed consent. And the Data Practices Office website also has sample templates that government entities can use to obtain informed consent from a data subject. Okay, here's another question that we received involving personnel data. What is considered a disciplinary action for the purposes of Section 13.43, Subdivision 2? This is important because the final disposition of any disciplinary action is public, along with the specific reasons for the action and the data documenting the basis of the action. In short, whether discipline has happened affects the classification of certain data. The quick answer to this question is it depends. Section 13.43 does not provide a definition of disciplinary action, which means that each government entity has some discretion to determine what may constitute formal employee discipline. That said, all government entities should take some time to think through what types of employer actions may be disciplinary in nature. Entities should review contracts they have with employees regarding potential disciplinary processes and actions. Additionally, policies and procedures related to employee conduct may be other documents that discuss and define formal discipline. There are also some older advisory opinions where the commissioner addresses whether certain employer actions are disciplinary in nature, which would result in certain data about employees becoming public. In those opinions, the commissioner does really focus on entities' written employee conduct policies, as well as the language of employees' contracts to help determine whether discipline occurred, which only reiterates the importance of having written policies in place to describe what is or is not a formal disciplinary action against an employee. All right, here's another question that we've covered once before, but we've been seeing it come up again a few times recently. So it certainly seems appropriate to discuss it once again. Here we have employees at many different government entities that are including preferred pronouns in email signature blocks, such as he, him, she, her, or they, them. As a result, many government entities are wondering what the classifications of pronouns are when they appear in this context in the email signature block of an employee. So the answer to this question is that it probably depends, and there's not necessarily a clear answer under Chapter 13. So answering this question will require some risk assessment on your part. However, here are some considerations that you should keep in mind as you're thinking about this issue. As I mentioned earlier, Section 13.43, under Section 13.43, the public presumption is reversed, which again means that personnel data are presumed to be private unless the data are specifically designated as public. Section 13.43, subdivision 2, does not designate personal pronouns as public data, nor does any other section of Chapter 13. However, Section 13.02, subdivision 5, indicates that data are not data on an individual if, quote, the appearance of the name or other identifying data can be clearly demonstrated to be only incidental to the data, and the data are not accessed by the name or other identifying data of an individual. So, depending on your analysis and considering the way your entity maintains email data, there may be some room to determine that the employee and/or the signature block are not the subject of the data and are merely incidental to the other data contained in the emails. Additionally, you may also want to consider whether your entity has a policy in place requiring employees to include preferred pronouns in an email signature. If your entity requires employees to include preferred pronouns in a signature, the analysis may involve more considerations that the pronouns are private personnel data that employees are required to provide to the entity. However, there may be less risk when employees choose to include preferred pronouns in an email signature block because the employee has chosen to disclose data to others voluntarily. Overall, I think this is a tough question where you'll want to weigh the risks with your entity's legal counsel to make sure you are comfortable with whatever decision you ultimately make. So another question we've seen a few times this month is about the classification of individuals' contact information, such as addresses, telephone numbers, email addresses, etc. Specifically, a question we received is whether government entities can cite Section 13.356, which governs personnel contact and online account information, as the justification to redact all contact information for individuals when responding to data requests. The language of Section 13.356 applies only to telephone numbers, email addresses, and similar online account information that individuals submit to a government entity for notification purposes or as part of a subscription list for an entity's electronic periodic publications. In these situations, the data would be private. In other words, Section 13.356 classifies only a few types of contact information in specific circumstances. So government entities cannot apply this section and the private classification more broadly to all individuals' contact information that entities might be maintaining. Furthermore, the Data Practices Act doesn't contain a section that generally classifies all contact information of an individual as not public. Individuals' contact information, such as their names, home addresses, telephone numbers, or email addresses, are going to be presumptively public in most situations, unless a specific provision within the Data Practices Act classifies the data as private or confidential. All right, let's do one last question here focused on the open meeting law. We have a public body that needs to schedule a special meeting. So the question is whether members of the public body are able to email each other to determine the best time to meet. As an initial point, public body members emailing each other directly creates a pretty significant risk that the body will violate the open meeting law. That said, members probably can email one another without violating the law, so long as the purposes of the email are solely to schedule a meeting. Remember, the open meeting law's requirements are triggered when a public body has a meeting. However, the law doesn't provide a definition of meeting, so we have to turn to the definition the Minnesota Supreme Court provided in Moberg versus Independent School District number 281. There, the court wrote that a meeting that is subject to the law happens when there is a gathering of a quorum or more members of the governing body at which members discuss, decide, or receive information as a group on issues relating to the official business of that governing body. In most situations, members trying to coordinate their schedules probably doesn't rise to the level of issues relating to official business that would trigger the open meeting law. However, public bodies may want to keep some additional considerations in mind. First, Even though it's probably not a technical violation of the law for members to discuss when to schedule a meeting via email, public bodies should also consider the public perception of these discussions. Often, the public's belief that a public body is violating the law can be much more challenging to work with, especially when there may be concerns from the public that board members have used emails to discuss more than just members' availability to meet. Additionally, an email chain among all public body members could unintentionally result in an open meeting law violation if one member sends a reply all response that is about official business. I'm sure, as we all know, it's pretty easy for a reply all incident to happen. So public body members certainly need to be careful about the content of emails when responding to each other to coordinate meeting times. In these situations, really a better way to manage would be to have the public body staff coordinate the scheduling of special meetings. For example, staff could send a blind copy email to ask all members about their availability for a special meeting and then schedule that meeting accordingly. Using that BCC function in an email can really help ensure that public body members don't slip up and accidentally email each other about official business, and which results in an inadvertent violation of the open meeting law. As a final disclaimer on this last point, public bodies should also make sure that staff are not being used as a workaround for members to discuss official business with each other or to make official decisions. Coordinating decisions through a central staff person would likely be a violation of the open meeting law, which the commissioner has previously discussed in advisory opinion 09-020. Okay, so those are our questions today. So we have plenty of time to take a look at some of yours. Feel free to send those questions into all panelists so we can make sure to see them. And then also, as just a reminder, if you don't hear us talking for a few minutes, that's because we're reviewing the questions and make sure that we're gathering up our thoughts to answer them sufficiently. While we're going through questions, I'm also going to put a poll up on the screen. So if you could please fill that out and let us know how we did today and what other topics that you'd like to see in the future, that would be a great help to us. And so we will turn it over to the Q&A now.
All right. Please feel free to send in your questions. I'm going to start with the first one that we have, which is per 13.825 subdivision 8, may law enforcement provide a copy of active or inactive body-worn camera video to a social worker assigned to a child protection case, and should they sign an authorization form for release? This is a good question. I think it's kind of a complicated one, so I will give a brief response here and follow up with the person who asked the question. I think this is another one of those situations where when the legislature was considering 13.825, which is the body camera statute, they didn't necessarily contemplate this piece of sharing. That certainly happens a lot with other kinds of law enforcement data. So the child maltreatment statutes are in Chapter 260E, and there are a variety of provisions in that chapter that talk about law enforcement coordinating their investigations with local social services so that there isn't duplication of investigative efforts. And there's also provision specifically in 260E.35 that talks about active law enforcement data, active investigative data from law enforcement in the hands of social services. So it's clear that not public data can certainly move from law enforcement to social services when they're doing a 260E type child maltreatment investigation. But it is not as explicit as it could be. So there is some kind of risk assessment and interpretation there. But I do think that the statutes read together contemplate some sharing of that information. Another question is, do the recorded closed meetings to discuss litigation become public once the lawsuit has been settled? And part of that is going to depend on if, if you're using the attorney-client privilege, if you're a public body and you're using the attorney-client privilege exception to the open meeting law to close a meeting. Generally, the privilege can last longer than the litigation. So I think it's a discussion with the client and the attorney to determine what parts of that recording, possibly all of it, where a client might be seeking advice from their attorney, should stay public. I'm sorry, should stay private, or is attorney-client privilege data that's taken out of the Data Practices Act, or if there's some of the discussion that could be provided to the public. But generally, if you're closing for attorney-client privilege, that privilege can last past the end of the litigation.
Okay, we are still here. We're waiting for more questions. So if you do have them, please feel free to send them in. Just send them to all panelists. But yeah, we're just waiting on some more questions here.
And I can just follow up a little bit on that last question too, to remind public bodies that as clients, they certainly have the option to waive attorney-client privilege. So they can certainly choose that as well. And then some of those recordings would also become available.
Okay, we have a question here about, can we clarify if phone numbers should or should not be given out? That's a great question. And again, it really depends on the context for why a government entity uh, is maintaining those phone numbers. And so if it's because someone has reached out and said, hey, I have some concerns that my trash wasn't picked up this week. Could somebody from the city please give me a call back? There's not really a classification for kind of general city concerns or general kind of questions to a city in that sort of way. So in those situations, a person's telephone number would probably be presumptively public. Now, if it was a situation in which the telephone number was collected as part of law enforcement data, and then that person qualified as having a protected identity under Section 13.82, Subdivision 17, then that telephone number would probably be classified as private and you couldn't disclose it. And so again, there's not a single classification for phone numbers generally. It always really depends on the reason you're maintaining the data or the context that you've collected it is really going to determine what the classification of that is. But as a general rule, I think under the Data Practices Act, you have to assume that it's presumptively public, that telephone numbers are presumptively public, unless you can point to something within Chapter 13 or a similar law to say this is classified as not public. So there's not all telephone numbers are not public or anything like that. It really depends on the context and the reason that you have that telephone number.
Thank you for this. Somebody just did want to clarify that meetings closed for attorney-client privilege do not have to be recorded. So they are not required to be recorded. To the extent they are recorded, then you might have to make some decisions. But all other closed meetings have to be recorded, but those under the closed under the attorney-client privilege exception to the open meeting law do not have to be recorded. Thank you for bringing that up. We have a question, another question regarding attorney data under 13.393. It says advisory opinions have said that this data is not subject to Chapter 13. Therefore, do we need to cite 13.393 if withholding it from a data for a data practices request? The requirement under Chapter 13 in 13.03 says that if a responsible authority or designee determines that the requested data is classified so that the person can't get access, they will inform the person about how they, the requester about how they are making that determination. So it is true that the data are taken outside of Chapter 13, when it's attorney data, but I think still providing that explanation to a requester is helpful so that they understand why they aren't getting access to something.
All right, we do have maybe about 1 or 2 minutes for a final question. So if you do have a final question, feel free to send it in. Okay, so don't see any more questions out there today. But of course, if you do have questions, feel free to reach out to us in the future. Here is all of our contact information for how you can stay in touch or reach out to us. We'd be happy to answer any questions that you have. We are available and to answer all of your data practices and open meeting law questions. And again, thanks for your time and your attention today. Do stay tuned for a Gov delivery notice for our next webinar for next month in April, which will focus on issues related to body cameras. We will also be hosting a government personnel data workshop in April, which we'll also announce through the Gov delivery messages, and that should be coming out in the next couple of days here. So again, thank you for joining us and have a great day.